interest. 2, a uniform national standard for the investment advice industry. And 3, improved disclosures regarding fees and conflicts of interest through the new form CRS so that investors can make informed decisions. Importantly, FINRA, MSRB, and the Department of Labor are also taking steps to align their rules with Reg BI. Such alignment protects investors with a common set of standards that streamline compliance and reduce unnecessary costs. While we are encouraged by the implementation of Reg BI and actions to support it, several challenges remain. First, we are mindful that there are a number of states that are considering separate fiduciary standards that can conflict with Reg BI. As an example, Massachusetts' new rule goes into effect in September. Second, we need to keep our eyes on additional attempts to undermine Reg BI, whether through court appeals or actions taken by a potential new administration. We have a great panel today that will explore, amongst other issues, Reg BI implementation and litigation, the importance of the DOL rulemaking aligning with Reg BI, and the various challenges that continue to face Reg BI. I'd like to introduce our moderator, Mark Sheff, a senior reporter with Investment News, who covers legislation and regulations affecting retail investment advisors and brokers. Prior to joining Investment News, Mark has previously written about employment and labor law as a correspondent for Workforce Management, served as a director of external relations at the Center for Strategic and International Studies, and served as press secretary and deputy press secretary for the late Senator Richard Lugar, a good friend of the chamber. Mark has maintained a long-standing connection with his home state of Indiana, where he attended Purdue and continues to contribute to Howley Politics Indiana, a weekly political newsletter based in Indianapolis since 1997. Mark, welcome, and let me turn the program over to you.
Thank you, Tom. It's a privilege to host today's event. I appreciate the invitation from the chamber. We have 3 panelists who are experts in this area, or in all the areas we're going to cover. Let me introduce them one by one. Troy Paredes is a former Securities and Exchange Commission member. He served on the commission from 2008 to 2013 and wrote an influential dissent to a study in 2011 with his colleague Kathleen Casey to a study of fiduciary duty that has helped lead us to where we are today. Prior to joining the chamber, Troy was a law professor at Washington University in St. Louis. He now runs Paredes Strategies, where he advises on financial regulations, compliance, risk management, and regulatory strategy. Also with us today is Brad Campbell. Brad is the former Assistant Secretary of Labor and head of the Employee Benefits Securities Administration in the George W. Bush administration. He is now a partner at Faegre Drinker, Biddle, and Reith.
Wow, you got it all out. Well done.
And our third panelist is Brian Richmond. Brian is an associate in the DC office of the law firm Gibson, Dunn and Crutcher, which is well known for its securities law practice. Brian represents clients in appellate, administrative law, and litigation matters, and also leads cases challenging agency rulemakings. Prior to working at Gibson Dunn, he was a compliance officer at Goldman Sachs. So we'll begin with opening statements from each of the panelists, and Troy Paredes will go first. Troy, the floor is yours.
Great, thanks. It's wonderful to have a chance to be here, and thanks for the opportunity to Tom and everybody else at the chamber who had a hand in putting this together and invited me to join you. I'm just going to hit a couple of points. I know there'll be time for discussion, and there's a lot that we could get into. The first thing I want to say, and it echoes a bit of what Tom was saying, which is, from my perspective, regulation best interest actually is a big deal. I don't think we need to spend the time here to unpack all the ways in which everybody listening in, I think, is familiar with it, but to the summary that Tom offered, the enhanced disclosure requirements, the duty of care obligation, as well as the a loyalty obligation to not only have proper disclosure, but the mitigation around conflicts and all that that entails, building out a compliance program, is in fact a big deal. And so the question now is going forward, so what is this all going to mean? And with that quick starting point, a couple of things I want to note. The first is as things evolve at the SEC over the next number of weeks and months, it's going to be examination and inspection time, as the Commission has indicated. What is important about that right now, in addition kind of normal course in the way in which examinations and inspections take place, is the focus this initial go around is going to be whether or not there was, a good faith effort to implement. And what I want to underscore there is that while the Commission has said and the staff has said their focus is going to be on a good faith effort to implement, I think what that reflects is a recognition that it's going to take time for the Reg BI compliance regimes to get, I'll say, fully up and running. That's not to say that you don't have your compliance obligations, but as with any new regulatory set of requirements, particularly ones as far reaching as this, and as to any new compliance programs that are being built out, it's going to take some time to fine tune. And I think the recognition on the part of the folks at the Commission is that that's the case, not looking to play, gotcha out of the box. And so long as there is this good faith effort to implement and folks really are trying to get it right, there's going to be the opportunity for some learning all the way around. I would imagine some learning on the part of the Commission to see the different ways in which broker-dealers of different shapes and sizes, business models, and the like have gone about the implementation. But then at the end of that process, from the initial exam cycle, what I think you then further expect to see is a set of observations or findings, however they actually fashion it, coming out of the Commission to say, hey, here's what we've seen. Here's what we've seen that's working well. Here's where we see opportunities for improvement. That's going to be really important because it's going to tell you what the Commission has had a chance to see and observe based on all that they've had a chance to look at. What will then be key as a practical matter is for broker-dealers to say, all right, in light of that, not only perhaps in light of their own experience if they were examined, but in light of whatever the Commission puts out by way of observations and findings from the initial go-around, to say, all right, as a broker-dealer, how do we measure up? What are the lessons we can learn? What are the lessons we can learn from what the observations are that the staff puts out at the Commission following on these examinations? But in addition to that, over the period of time, the next weeks and months, firms themselves doing the ongoing monitoring that's expected of them, frankly, expected of any effective compliance regime, to identify for themselves, well, we built this compliance program, we put it into place, but that's not the end of it by any stretch. In some sense, that's the beginning of it. The question then is well, is it working? How is it working? Is it designed effectively? Is it operating effectively? Are there things that we need to adjust? Some of that is simply going to come from the learning of the experience of putting the compliance program in place and your experiences, and again, what the Commission ultimately shares in terms of what they observe coming out from their examinations and inspections. So that's something, again, very much to be keeping alert to and staying on top of. I'll just give one other quick note, which I think is encouraging and quite helpful. OC, the Office of Compliance Inspections and Examinations at the Commission, earlier this year already put out some alerts indicating some things that they're particularly mindful of, what they may be asking for by way of document requests. Chairman Clayton put out a statement on some issues that he thinks need to be paid careful attention to. I would encourage folks, as a practical matter, if they haven't had time to sit down with those things that have already come out of the Commission pre-June 30, to do so, because it tells you some of the things that are already on your regulator's mind. And so therefore, it would follow ought to be on your mind as well in terms of your ongoing monitoring and assessment of the compliance programs that you just put into place.
Thank you, Troy. Next, we'll go to Brad Campbell for an opening statement. Brad, go ahead.
All right. Well, thanks, Mark. And Troy, let me say that was a perfect setup for what we want to talk about, what I want to talk about, which is sort of the intersection between what the Department of Labor is doing, rollovers, and activity with Regulation BI related to that. Because on June 15th, so 2 weeks before the rule went into effect here at the end of June, Chair Clayton was highlighting rollover issues, advice given to, recommendations given to participants in 401k plans and IRAs to roll those into other accounts, to roll those from plans to IRAs, and so forth, as one of the highlighted areas that this commission is going to be focusing enforcement on. And that's also, of course, one of the primary areas that the Labor Department is recently announcing a new focus on. the department has proposed a new class exemption, which is intended to facilitate investment advice, fiduciary investment advice, by addressing some of the conditions that need to be met to receive commissions, to receive 12B1 fees, and a variety of other forms of compensation. And what DOL has done in this proposed class exemption, and the comment period on it ends next Thursday, so we're still in the comment period. They proposed it essentially when Reg BI went into effect. The effect of this class exemption would be to harmonize some of the requirements between ERISA and the securities laws, in particular Reg BI. So the conditions that DOL has put into this new proposed class exemption very closely mirror those of regulation best interest. They include certain disclosures. They include the adoption of certain policies and procedures. They include a best interest recommendation, which is essentially the same language from Reg BI. And so what that does is it makes the compliance burden substantially less for folks, particularly in the broker-dealer space, because what DOL is wanting to see on its side of the fence is now being very closely aligned with what is now being required to regulation best interest. And so this is an example of how we're seeing those two agencies cooperate in a way to try and make the compliance burden less and to facilitate the provision of advice to the participants and beneficiaries, again, particularly with rollovers. And what I want to emphasize with rollovers is that Reg BI puts in place sort of additional guidance and language beyond what FINRA had put out back in 2013, really describing what it is you need to look at when you're advising a participant on a rollover, taking into account not just how they're invested in their plan, but how could they be invested in their plan? What are the options in their plan? What are the fees? What are the services that are available? So that you can then compare that to the IRA you're recommending or could recommend, depending on the outcome of that analysis. And they pointed out in the information that Reg BI, it isn't enough just to say, well, there's more options in the IRA. You actually have to evaluate all of those things to come to the conclusion that if the IRA is more expensive, that on net, that is in the best interest of the participant because of the additional benefit. And that dovetails with where the Department of Labor is also going, looking at rollover issues and sort of changing to some extent the guidance about when and how a recommendation to rollover is also ERISA fiduciary advice. So that's a good example of where a broker-dealer, a registered rep of a broker-dealer is recommending a rollover. They're simultaneously regulated by DOL and by SEC. And having those standards come together is beneficial to all parties to make that process function more efficiently.
Thank you, Brad. And now, Brian Richmond, go ahead and give your opening statement.
Great. Thank you, Mark. And thank you to the Chamber. It's great to be here with everyone today. Right now, I'd like to focus on the litigation surrounding Regulation BI, and in particular, the Second Circuit decision in a case called XY Planning Network versus SEC that came out at the end of June, just to give you an overview of what happened there and where things currently stand in the litigation landscape. So we can break this opinion down into really three main issues. So on the first, you have the jurisdictional issues, then you have the statutory interpretation issues, and then finally you have your normal arbitrary and capricious arguments under the Administrative Procedure Act. So I'll try and hit those in order right now. So on the jurisdictional side, there was an initial question of standing. So whether any of the three petitioners actually had standing to challenge challenge regulation best interest. And here was a bit unusual in the context of which it arose. Generally speaking, in a lawsuit to an SEC rule, the challengers are actually the regulated parties, the industry that is subject to the regulation, and their standing is obvious. Their injury and any harm to it flows from whether or not the rule stands. Here, what you had was a coalition of state attorney generals, an association of investment advisors, and an investment advisor challenging regulation best interest, a rule that does not directly apply to them. So in order to jump over this jurisdictional hurdle, they had to look for other methods of showing injury. And the court accepted some and the court rejected others. So as for the states, all three judges agreed that the states did not have standing to pursue their claims. And now the state's theory here was built off of a few speculative leaps. So the state said, well, the Exchange Act requires, if the Securities and Exchange Commission goes down the rulemaking process here that is going to go down, the Exchange Act requires it to equalize the standard of conduct between broker-dealers and investment advisors. Because the SEC did not do that, that will allow brokers, in the Commission's view, to give conflicted advice. If the brokers give conflicted advice, that will depress investor returns. If investor returns are depressed, that will ultimately lead to less tax revenue coming into the states. All the judges rejected this for two main reasons. First, as you could see from that, it's just, there was no empirical grounding to it. It's just speculation on the state's part. And there's not a direct link between Reg BI and the potential loss of tax revenue. And secondly, the states did not address the findings of the Commission that equalizing the standard of conduct between the two by imposing a fiduciary standard on brokers would actually increase costs on investors, which would balance out. So it wasn't exactly clear whether or not investor returns, even under the state's theory, would be higher or lower. And then that gets to the second petitioner here, Ford Financial. So this is an investment advisor, and two judges found that Ford did have standing. Ford's theory was one of competitive injury. Basically, Reg BI would put brokers at a competitive advantage to Ford, an investment advisor. So what Ford said is, Ford's advertising would be, you should hire me, Ford, an investment advisor, because as an investment advisor, I have a fiduciary duty. Brokers don't. So I will look into your best interest. What he said is, well, now that you have Reg BI, the best interest component of Reg BI, that will take away part of my argument. I won't be able to say, I have this superior standard, so you should come to me. But at the same time, it will not subject brokers to the full requirements of a fiduciary duty. So it will, they'll get the benefit of being able to invoke Reg BI, which will counteract my advertising, but they won't be subject to the full costs. Two judges accepted this, so Ford's claims were able to go forward, and the court ultimately decided the issues. Judge Sullivan dissented just on this standing ground. He would have found that Ford, and in fact, none of the petitioners had standing, under the theory that if you vacated, the court could not possibly give Ford relief. Even if you vacated the Commission's rule, Ford would still have a more, in Ford's view, more stringent standard. Ford would still be subject to the fiduciary standard, and the broker-dealers wouldn't. So it would not narrow the gap in terms of cost at all. So that brings us to the meat of the actual argument, the statutory argument. So what the petitioner said is that while the SEC had discretion on whether or not it was going to initiate a rulemaking to address the standard of conduct of broker-dealers, once it went down that route, once it initiated the rulemaking procedures on this, it had no choice but to equalize the standard of conduct between investment advisors and brokers. And the court rejected this. What the court said is the language in Dodd-Frank, so it's section 913 of Dodd-Frank, gives the SEC broad discretion. They may commence a rulemaking to address the legal or regulatory standards of the care of broker-dealers. And the court agreed with the Commission that gives the SEC the discretion on whether or not to initiate a proceeding, and then in that proceeding, what standards it could actually apply. It rejected the state's or Ford's argument that another provision in the Dodd-Frank Act, another part of 913, which authorized the Commission to impose a fiduciary standard, was inherently linked to that. The court said these are separate standards. If the Commission wanted to invoke that, it could. And then finally, there was the normal arbitrary and capricious arguments under the Administrative Procedure Act. So one was that the SEC had erroneously linked its decision to an interpretation of the exemption for broker-dealers under the Investment Advisors Act. And the other was that the Commission failed to consider investor confusion in this. And the court easily dispatched both of them. It concluded that the commission, that Reg BI had nothing to do with the commission's interpretation of a particular exemption under the Advisors Act. And then as for investor confusion, the court said that the SEC addressed it head on. The SEC acknowledged that investors could potentially be confused between the different standards that might apply to a broker-dealer and to an investment advisor. But because the SEC acknowledged it, and because it found that other priorities outweighed it, such as increasing investor choice or decreasing potential costs, that was a choice that Congress had delegated to the commission, and the court was not in a position to second guess that. So at the end of the day, this decision should provide some certainty, at least in the short term, that Reg BI is here to stay, and this really knocked out the main challenge to it. So going forward, brokers at least have an idea for now what standards are expected of them.
Thank you, Brian. I'll begin the Q&A with some questions, and I encourage everyone watching the webcast to submit questions in the chat. Try to make them as short and to the point as possible. It'll help me sort them out, and we will go from there. I'm going to ask each of the panelists a question to begin. Troy, I'll start with you. Reg BI does not define best interest, nor does it outline how brokers should mitigate conflicts of interest. As you said, there will be a range of learning on Reg BI. How big a range of interpretations of those two elements do you foresee? And could you give us an example of interpretations of what best interest really means and what mitigation really means?
Well, I think the range could be quite significant, but let me unpack that a little bit. I think the reason for that in part is different broker-dealers have different businesses at some level, have different customer bases, different fee structures, and while there may be some similarities, the details matter. The details matter when you're doing a conflicts assessment, for example. The details matter in terms of how you then think about what the right mitigation strategy is. There's room for different good faith, reasonable judgments to be made about how much mitigation needs to be coupled with what kind of disclosure in order to address certain conflicts in those instances where the commission has said that disclosure itself may not adequately address a conflict. So for those reasons, you're going to see in the beginning, particularly, I think, a pretty sizable range, but that's not so atypical. By that, I mean, you can think about lots of different regulatory regimes or new requirements when they're put into place that there is more varieties, if you will, a wider range in terms of how it was implemented. And that starts to then coalesce at least around the more major components over time. Over time, as people, again, firms assess their own compliance programs and how effective they are. But over time, as the regulator increasingly says, hey, we know you might have thought this, but now we're telling you it's not this, it's that. And so you need to course correct. The other way in which, of course, it comes up and will come up is through enforcement. And we could talk a lot about regulation by enforcement. What is regulation by enforcement? What's not regulation by enforcement? But just being descriptive on the point for a moment, we're going to get the exams. We'll get some findings. Maybe we'll get some additional FAQs and guidance. We'll get what we get out of the exams, not just the initial round of exams, but exams ongoing. But there will be enforcement actions at some point. That is kind of par for the course, if you will, in terms of regulatory regimes. I was thinking about it in the context of BI. You know, we haven't seen the last enforcement action for purposes of Section 206 under the Investment Advisors Act, which of course has some analog or analogy to what the Commission did in terms of best interest when it comes to the foundational principles. And in fact, when the Commission adopted Reg BI, they also adopted interpretation and guidance on 206 of the Investment Advisors Act. So these things will, in some sense, be in some measure of flux for a very long time. You will have room for good faith judgments, for there to be some variation. It's more principles based than prescriptive, but it will be this: how do things change over time with the learning, again, from one's own assessment, but also in terms of what the Commission and staff say in terms of their expectations of how things are playing out.
Great, thank you, Troy. Brad, I'm going to go to you next. You've said that the DOL fiduciary proposal includes important guidance about rollovers in the preamble. And I'm wondering if you could explain to us, why is that important that it's in the preamble rather than in the rule proposal itself? And what does that all ultimately mean for rollovers?
Yeah, it's actually a very interesting approach the department's taken in this rule. So they've put out the proposed class exemption on which they're taking comments. This is a regulatory and administrative action. But in the preamble, they described new guidance that they're putting out. That's not a notice and comment rulemaking. That's essentially them saying, previously, we had an advisory opinion that reached the conclusion that most rollovers would not be ERISA fiduciary advice. We think we were wrong in our previous advisory opinion. We're rescinding it. And here is the new way that we're reviewing, that we, the department, view some of the key terms in the 1975 regulation that defines when fiduciary investment advice is being provided. So that is, as best we can tell from looking at it, and it's sort of an unusual way they've done it, it would appear that that is now their official position, that they have, as of July 7th, taken the view that the old advisory opinion no longer applies and this new analysis applies. And the new analysis takes a more expansive view of the regular basis requirement in the 5-part test and a few of the other elements, such that it is more likely that rollover recommendations will be ERISA fiduciary advice in addition to whatever other regulatory structure applies. So again, a broker-dealer who's recommending a rollover would have regulation best interest and its provisions applying, as well as the ERISA fiduciary standard. And the primary effect of that would be that the ERISA fiduciary would need to use an exemption in most cases to make it permissible for them to receive compensation for that advice. So there's probably more to come from the department on this, because the guidance they put out, I think, will naturally raise some new questions as well. And we'll probably see people offering comments on the guidance, even though it's not technically up for notice and comment, as part of their response to the comments on the class exemption.
Thank you, Brad. And Brian, looking at the Reg BI lawsuit, the plaintiffs, at least the investment advisory firm plaintiffs, have said that they may ask for an en banc hearing in the Second Circuit. They may ask for Supreme Court review. What do you think the chances are for each of those, en banc and then the High Court granting cert?
I think their chances are pretty low in terms of a grant of either en banc or cert review. I mean, as for en banc, the Second Circuit is very hesitant to grant en banc review. It generally grants less than any other circuit out there. So they would have to overcome a lot. In terms of the attractiveness of the case to the en banc court or to the Supreme Court, I think it's pretty low, and that's for a couple reasons. So as for the APA arguments, the standard arbitrary and capricious arguments, those generally don't interest the Supreme Court. They are unlikely to interest the en banc court. It looked like a relatively straightforward application of the APA. As for the merits of the statutory argument, those statutory arguments were more likely to interest the en banc court or the Supreme Court. But here you had all three judges agreed on the actual statutory interpretation. Even Judge Sullivan, who would have found no one had standing, he noted in his dissent that he was in agreement with the majority. So you have no judge that we know of now who at least disagrees with the statutory argument. The statutory argument makes sense on its face. It has a lot of force to it. The Act does seem to give the SEC a lot of discretion in this area. And then there's also whether or not this is a good vehicle for either court to hear. And I don't think it is, because whether it's the en banc court or the Supreme Court, they're going to have to address the issue of standing. And they're, before they're able to get to the merits. So to the extent the merits interest them, there's a substantial risk that they wouldn't even get there. So right now you have two judges who found standing for only one of the plaintiffs. Everyone agreed, the states did. And then you had a judge, Judge Sullivan, who dissented even as to the one petitioner that made it through. And Judge Sullivan has a strong argument on his, a substantial argument on his side that even if the court was to agree with the petitioners and vacate the rule, at the end of the day, their harm is there's still a gap between the standard for brokers and for investment advisors. So it doesn't give them even the relief necessarily that they're seeking. So I don't think you're going to see a grant from either court.
Thank you. We have a question from the audience, and let me put it in this context because it was a question I was going to ask as well. Of course, we're in an election season, and the Democratic Party platform draft that was put out last week has a few lines about investment advice reform, and it makes clear, without naming Reg BI or the DOL fiduciary proposal, that Democrats are not happy with Trump administration policy on investment advice. So, Brad, let me start with you on this question. Here it is from the audience member. Has the Department of Labor taken appropriate steps to protect the PTE, Prohibited Transaction Exemption, proposal from attack under the Congressional Review Act of the Administrative Procedure Act? And the questioner, I'm sure, is assuming, or at least that question sort of assumes the Democrats would take the Senate too. What happens at that point? Biden in the White House, Democrats controlling the House and Senate. What happens to the DOL fiduciary proposal?
Yeah, so when it comes to the regulatory agenda of the Trump administration in general, not just the DOL, there's kind of two big avenues of risk if President Trump's not reelected. One is the powers of the incoming administration to deal with regulations that haven't been completed timely. And the rule of thumb there is that if a regulation has been published in the Federal Register as a final rule for more than 60 days, it's generally deemed to be a valid regulation, even if it hasn't gone into effect yet. So in other words, to remove that regulation, you would have to do a notice and comment rulemaking, or you'd have to take some kind of administrative procedure step. It wouldn't be as easy as just stopping it in its tracks. If it's less than 60 days, it's actually relatively simple for an incoming administration to stop something. So as to the first question, what has the Trump administration done to try and get the class exemption finalized? Well, I think the first indicator is they proposed it with a 30-day comment period, which is shorter than we would normally see. And I think their intention would be to get that exemption granted in final form, presumably by October, so that it would definitely be on the books long enough to require a new regulatory action to undo. So that's what happens if you're just looking at a change in the administration. If there is also a change in Congress, such that both houses of Congress and the administration are all in the same party, then the Congressional Review Act could be used, and the time frame there is actually 60 legislative days. So you have to look back to how many days was Congress in session to go back to when is the drop dead deadline for Congress to not be able to pass a resolution undoing a regulation. And probably we're already past that. Given it's an election year and everything going on, we probably have already gotten inside that 60-day window, probably back maybe in May or June. So chances are, if there's a full sweep in the election, that the Congressional Review Act may well be used for a variety of things. It rarely can only be used, it's not used very often because you do have to have the agreement of Congress and the administration to undo a rule. And typically a president's not going to sign off on undoing his own rules. So you have to have both that change in administration and the control in Congress for that to come into play.
Right. Troy, you were appointed to the SEC by President George W. Bush. You served for a couple of years in an SEC that had a Republican majority, and then you served, or maybe not a couple of years, but not a couple of years. But anyway, you were appointed by Bush in 2008, and you served well into I mean, you served a full term of the Obama administration when Democrats had the majority on the SEC.
Yeah.
So Reg BI is different, of course, from the DOL fiduciary rule in that it is set in stone, as Brian has told us. It's survived a court challenge. It has not only gone final, it's also been implemented. How difficult would it be for a Biden SEC to undo Reg BI?
Yeah, well, I think the question is by undo, what does one mean? And I think a little bit different than the DOL context, just given kind of the postures. I think the way it could work for Reg BI and the SEC is the criticism, the primary criticism, I think, including by those who dissented at the commission when it came to Reg BI, was that it just didn't go far enough, right? It went a distance from suitability plus FINRA plus, the anti-fraud provisions, the totality of what BDs were already subject to. It went well beyond that, but folks thought it should go farther still. So I think the impetus would be less to go back to, if you will, status quo ante, pre-BI. And rather, I think the things to keep an eye on is if you think about a majority of the commission sharing the view of those who have criticized BI as not going far enough, what would they do, or what might they do? Well, you can think about then what that would mean in terms of examination and inspection, and where the focus would be, and what might be considered a deficiency. You could think about that in terms of what might be considered a violation, what that then might mean in terms of priorities when it comes to enforcement, and what people think might rise to the level of warranting an enforcement action. That's all within the context of how you examine and inspect and enforce and interpret BI. In addition to that, BI could continue to exist. And instead of saying, well, let's quote unquote undo it, it could be, well, if we use that, where do we go then beyond it? So the posture, I think, is more along those lines as compared to, say, to use an extreme day one, how do we stop it in its tracks? Because to stop it in its tracks, but again, go back to status quo ante, I think it would be about the interpretation, the inspection, the examination, the enforcement, and then the question of, all right, is there something to do to replace or at least build upon, as some may see it, what BI currently provides for?
Right. And Brian, this is not necessarily an election-related question, but it does have to do with political leadership at the state level. A couple of blue states, so to speak, have proposed their own fiduciary rules. Of course, I realize Massachusetts has a Republican governor, but a Democratic Secretary of the Commonwealth, Bill Galvin. What are the chances that we're going to see lawsuits against state-level fiduciary rules when and if they go final? Massachusetts is final, but New Jersey and Nevada, if they go final. Oops. Did we lose Brian?
We might have lost Brian.
Oh, okay.
Well, if you don't mind, I'll jump into that question.
Brad or Troy, if you want to jump into that question, go ahead.
Yeah, I'll jump into that question because we've been spending quite a lot of time last year dealing with the issues in New Jersey and Arizona and Massachusetts. Right. And I think going into that, one of the big concerns was, can we really have a system in which each state puts in place contradictory requirements? And we were seeing an awful lot of details in New Jersey's original proposal and Massachusetts' original proposal that really fueled that fear. I guess you'd have to say the clever thing that Massachusetts did was reduce all of that additional conditions down to essentially a core fiduciary standard. And so that, I think, has caused a lot of question as to whether we should wait and see what happens in New Jersey and Arizona and other states before moving or not. So I think in some ways, the virus, frankly, has slowed down state activity on this and staved off a confrontation that might otherwise have already happened.
Right. Troy, I want to go back to something.
Mark, you have Brian here. Sorry about that. I don't know. My computer disconnected, but I'm calling in and I'm rebooting it now.
Oh, okay.
I'm here.
Did you hear my question?
No,
Oh,
sorry.
well, what are, and Brad gave us his perspective on it. How about you? What are the chances we'll see lawsuits against state level fiduciary rules in Massachusetts, which is final, and New Jersey and Nevada, when and if those two go final?
So I think there's a real possibility of it. So you have really two questions that potential challengers would need to consider. So first, you have on the strategic side whether it's better to go forward with the challenge and ultimately get some resolution to it, or to have that as leverage in your discussions with the regulators, kind of have that in your back pocket to try and get more reasonable concessions from what the states may be proposing. So they know that anything they put out is subject to potential challenge, and it's a helpful negotiating tactic. And what else could inform the decision is the actual strength of a potential legal challenge. So any state, if it's a regulation, it will likely be subject to potential challenges under state versions of the APA, but that's very state specific and very specific to what the state actually does. In addition to that, and I think this is where the meat of any challenge will come from, there is a potential preemption argument that federal law actually preempts a state attempt to impose a fiduciary duty on brokers.
Mm-hmm.
And what you have is an act, and the argument goes as follows. What you have is an act that prohibits states from imposing, as relevant here, record-keeping, books and record-keeping requirements above and beyond what is required by federal law. And the argument would be, well, by subjecting brokers to a new fiduciary standard, that inherently has a kind of book and record-keeping component to it. That's going to make the broker document their compliance, monitor how their personnel are complying and applying the rule. So by imposing this, the state is going above and beyond the books and records that federal law requires, and that is a substantial challenge. And interested parties could potentially bring that against any state action that we see here.
Okay, thank you. Troy, going back to something you said earlier about regulation by enforcement, some call it rulemaking by enforcement. This has been brought to the fore by brokerage industry groups who are criticizing the SEC over its share class initiative. These groups are asserting that the SEC did not provide a clear rule about how 12b1 fees should be disclosed and managed, and yet they launched the share class initiative. The disclosure of 12b1 fees and advisory accounts, of course, is a principles-based rule. Reg BI, as you mentioned, is a principles-based rule. What are the chances that these groups down the road, when these enforcement cases do come out for Reg BI, what are the chances they're going to say, hey, Reg BI is rulemaking by enforcement as well. You never told us how to mitigate. You never told us what best interest meant.
Yeah, I think we'll hear some of that at least at some point. And the reason I say at some point is I think there's a good chance that in the early days, I don't know if that's the first year, 18 months, 24 months, and again, realizing that things could change somewhat with the election to the prior point, depending upon the outcome, but that the commission will focus on the most egregious shortcomings, where folks would say, look, everybody, quote unquote, everybody, that's a strong statement, but knows you can't do that, or you must do the thing that this particular broker dealer didn't do. It's as you get farther down the road and those sorts of, more apparent manifest shortcomings have wrung themselves out of the system, or at least largely wrung themselves out of the system, that you get to some of these finer points. And you do see a lot of that in the context of disclosure in particular. I think you may see a lot of that when it comes to this question, or a lot of this concern around a debate around, what's adequate when it comes to this balance between substantive mitigation or conflict on the one hand and disclosure on the other. What's that balance? Right, the release talks a lot about that conceptually, but what does that actually mean in practice? A tiny bit of disclosure with a lot of mitigation, or a whole lot of mitigation with a lot, with a little. How is that going to work? I think is a big practical question, where I could see those sorts of critiques and concerns coming up at some point. The other piece too is just to note real quick is that disclosure is there are very fine distinctions that have been drawn in lots of different contexts when it comes to what constitutes a material misstatement or omission or an inadequate disclosure. One example people often will give, and this is not from the BD context, but the people will often give is this question of may versus will, right? So it may, it will, it has, it is. Those are all very fine distinctions, and the courts have spoken to that. But that one slight variation between may versus will has been found in some instances to constitute a material misstatement or omission. And so there's always that sort. So if you have that as a starting point, then you think about added to it questions around, well, it's not just whether or not the disclosure was fulsome enough, but you look at the release and a lot of focus on, well, was it understandable? Once you throw all of those sorts of things plus, conflict mitigation into the mix, there will be, I think, many occasions at some point down the road where people do feel as though the commission is either going too far and not really giving life to what it means for this to be a principles-based regulatory regime. But as you said, the critique often being fashioned as a critique of regulation or rulemaking by enforcement. I'm sure we'll hear that at some point, but I don't know that we'll hear that in the early days when I think the regulator will focus more again on those things that are clearly and more widespreadly agreed to be shortcomings, such as they may present themselves.
Right. And as we get near our conclusion here, just a couple more questions. Brad, you had the role in the George W. Bush administration that Phyllis Borsey had in the Obama administration, and many call Phyllis the architect of the Obama DOL fiduciary rule. I'm wondering what your assessment is of how far the Trump DOL has gone to undo what Phyllis and her colleagues did, and how do you respond to investor advocates who say the new proposal is basically tantamount to DOL giving up on investor protection in retirement accounts?
Well, I certainly would disagree with that last statement entirely. I think that's actually that's basically pure propaganda from someone who has an agenda to grind, because that's not at all the way DOL enforcement works. The ERISA fiduciary standards are the highest known to law. There's part of the reason the approach that the Obama administration took was such a problem was that by casting so wide a net in defining what was fiduciary conduct, it brought into the range of prohibiting all sorts of actions that even DOL itself conceded probably shouldn't have been prohibited. ERISA is sort of a hyper-protective other people's money statute that applies in ways that aren't obvious, I think, to a lot of folks at first. So part of the problem with the Obama administration rule was it created problems that even they had trouble trying to fix. And I don't think it's at all fair to say that enforcement has not been a priority for the Trump administration. I think if you look at their enforcement results, monetary results, they've been as good or better, I think, in many instances than during the Obama administration. But I don't think that's the case at all. What you have here with the new proposed class exemption is not a case where there's less protection. In fact, this new class exemption has more conditions than is traditionally the norm in class exemptions DOL has issued. So I think there's a misunderstanding. I guess I'd look at it this way. Back when we were emphasizing compliance assistance, the reason we did that in the Bush administration was by trying to help get into compliance the folks who were working in good faith but who made mistakes. That freed up investigative resources to go after true bad apples, people who are actually trying to violate the law. So we got a beneficial multiplier effect by having a good, robust compliance assistance program that helped people get where they needed to be while we went after the bad guys. And that was immediately criticized by Secretary Solis and the Obama administration, and the initial secretary, as, well, there's a new sheriff in town and now we're going to do enforcement. And I think you'll find their numbers actually went down the first couple of years. So I throw all that out there to say there's always these accusations back and forth about who's stronger on enforcement. The reality is the enforcement efforts of EBSA and the Labor Department are pretty consistent from administration to administration. They focus on the fiduciary basics and making sure participants are protected. And I think they've done a good job regardless of who's been in the White House.
Okay. And we just got a couple of minutes left. I don't see Brian on here. Is Brian?
I'm here. Can you hear me?
Oh, Brian. Okay, you're there. On in terms of other kinds of legal action that might be on the horizon, is there anything you're looking for?
I mean, I think the main thing is going to be challenges to. I think what the states are doing is where the action's going to be.
Mm-hmm.
I mean, right now, Reg BI is pretty secure. The Second Circuit had that decision, which leaves it in place for now. Yes, if there's a change in administration, a new commission could attempt to add to the requirements under Reg BI, but that would have to go through. They'd have to go through notice and comment rulemaking again, and anything they do would presumably be open to challenge. Because the Second Circuit said that a lot of this is given to the SEC's discretion, any new thing the commission adds would be subject to arbitrary and capricious challenge. So it would give administrative lawyers, it would give us something to work with during the comment period, and then ultimately during litigation to potentially challenge anything a new commission might do. But again, I think that's more in the long term. I think in the short term, where you're going to see the action is what states are doing. And then the question is going to be whether or not you're going to see a preemption challenge, whether someone wants to argue, no, federal law does not let you add these new additions onto brokers. That's what I think we should be looking out for. And
Okay.
Well, I would certainly agree that I think there's a lot of activity that's going to be happening at the states, but I do think the outcome of the election really is going to dictate how much activity there is here in DC. You posited, Mark, what happens if there's a clean sweep by the Democrats. In that case, I think you could see some pretty rapid changes to various regulatory positions, either through legislative change or through the Congressional Review Act. And also personnel is policy. Let's always remember, if Senator Warren is, enabled to, help staff the SEC, you're going to get some different perspectives there than you did before, and that could cause some fairly rapid changes. So I think the next election is really going to have a probably bigger impact on what the reality for financial regulation is than almost any other factor.
Okay, terrific. And my final question, just a quick answer from you, Troy, if you would. When the DOL fiduciary, the Obama administration's DOL fiduciary rule went final, and everyone was assuming that it would stay in place, we saw some almost seismic changes in the brokerage industry in terms of firms and creating new low and no fee products and eliminating commissions and retirement accounts and things like that. It seems that there have been far fewer pronouncements like that with the introduction of Reg BI. Do you expect major changes in the way brokers give advice that will be prominent and even put out in a news release?
Well, we've already, as you said, we've already seen some changes that happen because of that prior prompt. We've already seen some shifts in terms of brokerage versus advisory. At this point, in terms of a response to BI, I'm not expecting there to be some, as you described, kind of seismic type shift. Again, conflicts assessment, conflicts mitigation, policies, procedures, sound disclosure, those are all things. There is the point around compensation, speaking to conflicts, but all of that, I think, can be dealt with, managed, complied with effectively without necessarily calling for any sort of quote unquote seismic shift. I think to the extent we see business shifts, that's probably going to be more driven by setting aside whatever may happen on the regulatory front, depending upon the outcome of the elections, but more just generally by market demand, market interest, and those kinds of developments as compared to Reg BI unto itself.
Great. Well, Troy Paredes, Brian Richmond, and Brad Campbell, thank you for joining us today. This was a fun conversation.
Thank you.
Indeed, thank you.
Great, thanks, Mark.
Yes, and now we'll turn it over to Kristen from the Chamber.
I see you didn't want to attempt my last name.
I'm sorry.
Just joking. No, no, no.
I didn't think of my in social media parlance. I didn't even consider my outro. I'm very sorry, Kristen.
No,
If you would introduce
I'm
yourself, I'm sorry.
really just a light comedic moment.
Yes.
Thank you all. This was a really great discussion. We truly appreciate our attendees, our many member firms who've dialed in, and their questions in the chat room. I'd like to thank Mark Scheff, Brad Campbell, Troy Paredes, Brian Richmond again for their participation today and providing some really great insights around the many issues surrounding Reg BI and DOL. I think importantly, we've learned that Reg BI and associated fiduciary issues are going to keep us busy for a while and engaged. And the Chamber certainly is going to remain active on these issues. So we look forward to you reaching out to us with any questions or comments about Reg BI, the DOL, the upcoming DOL proposal, or ongoing state issues. So we thank you all for participating today and have a great remainder of your day. Bye.
Thank you.
Thank you all very much.
Thank you. Hey, Krista. Out of time.